Yeah, good afternoon, everybody. Welcome to our session on the role of NGOs in corporate climate mitigation in Africa. So we've got different NGO activists, representative NGOs from different parts of the continent. So we are still waiting for one person to join us. So we are very grateful to have everybody in this session. So in terms of climate justice, in terms of litigation in Africa, NGOs play a very, very fundamental role. So most of the cases that you tend to see in South Africa, in Nigeria, even so the Gbemre case is the first climate mitigation case in the world was basically facilitated by NGOs. So from an African perspective, NGOs play a very, very important role. We can talk about remedies, we can talk about implementation, but there's no climate litigation in Africa without the NGOs. So we are very, very pleased to welcome everybody to this session, and we hope to learn from the various perspectives of different NGO representatives in Africa. So where we are going to run this session is that we have a couple of questions for every panelist, and I'm going to ask you your question, then you respond. You have about 5 minutes to respond to the question. So we are going to go in the order of how the program has been organized. So I'll start with Mr. Brandon Abdinor. Sorry, apologies if I didn't get the name correctly. So he's going to be our first panelist for today. I'll just provide some background to what Brandon has done so far in terms of NGO activism from a South African perspective as well. So I'll just provide some details about his profile. Brandon joined the CCAO as a climate advocacy lawyer in 2021. He obtained an LLB from the University of Restaurant and was admitted as an attorney in 1998 after 7 articles at Routledge Incorporated in Johannesburg. He went on to fulfill various management and legal roles in the corporate sector before opening his own legal and consulting practice. In 2018, focused on dispute resolution and sustainability matters. He has acted as first as a board member, then consulting associate at EdLive, which saw him design and deliver legal rights training for grassroots communities as well as provide legal support. He is a climate advocacy lawyer, and a few days ago, I actually attended Brandon's talk about the Climate Change Act in South Africa, and he provided us some perspective regarding the potential of the climate change bill in South Africa. So we are very pleased to have Brandon in our session. So it's going to kickstart this session for us. So the general question for all the panelists that we have today is to basically say in terms of your experience being a lawyer, an activist in the environmental law, climate justice, climate change arena. So how can we tackle the effects of climate change impacts as a human rights concern? And so, what is the role of NGOs? How can NGOs bring such matters before our regional and sub-regional courts? So, is there a role for the regional courts and sub-regional courts in Africa in trying to align human rights considerations and climate change issues on the African continent? So, Brandon, can you just provide a background to what you do in terms of the NGO does, and in terms of the relationship between that and climate mitigation on the continent? Thank you.
Thanks, Dr. Ekato, and good morning or good afternoon, everybody. It's really good to be here and to be exchanging these ideas. So a little bit about the center. We are a public interest law organization, and we registered as a law clinic. So we basically act like a firm of attorneys or solicitors, and that law clinic status means we need to take on clients who don't have the resources to prosecute claims themselves through the courts. So our clients are generally either sort of kind of grassroots environmental groupings or slightly more formalized environmental NGOs. And we tend to work very closely together over extended periods of time. We engage in strategic litigation predominantly, so looking for those kinds of matters where a win could set a precedent that has a broader effect than just the case at hand. And then also extensive legal advocacy, engaging with policy, engaging with decision makers and other institutions of power. So to maybe answer the last part of the question first is, I think, using the regional structures. such as human rights tribunals and courts and that kind of thing. It's something that we have on our list, but it's not something that we have actually taken further at this point in time. At the end of the day, although we have enough resources to do what we do, they are still limited. So what we tend to do is go in sort of South African courts at this point in time to get kind of hard decisions as opposed to sort of soft law decisions. And I think there's place for all of them, and they're all important. And it's going to be really interesting to see, I think, what happens in cases where these more regional or human rights bodies make decisions. We've seen the Swiss government now deciding to overrule or disregard the European Court of Human Rights. We'll see what happens with the United Nations Convention on Law on the Sea. That advisory opinion has come out, the ICJ as well. So we're open to using those, but at this point in time, we tend to get really stuck into the nitty-gritty in our various branches of our High Court. To address the question of human rights, maybe to really draw on the cancel coal case that the Prof spoke about in the previous session. So this being a youth-led climate case, and the essential basis of the case is challenging the government's decision to procure 1,500 megawatts of new coal power. So our fossil fuel fight in South Africa is possibly different to many others in that the main fossil fuel that we've been combating is coal. There's an abundance of it, and certainly our electricity generation system is strongly dependent on that, with the energy sector contributing over 80% of our greenhouse gas emissions. So we're in a situation where we need to see the existing coal plants phased out as quickly as possible, against the context of an electricity crisis. That's very challenging, but it's ongoing work. But when we saw that they want to procure yet a couple of new coal-fired plants, we thought, now it's time to draw the line. So we made a case out that because of the climate change harms that come from burning of coal, it would infringe a number of the rights in our Bill of Rights. So we've got a strong constitution, and the Bill of Rights, the obvious one is Section 24, which is the right to an environment that's not harmful to health or well-being for present and future generations. So that future generations one is obviously a strong angle in this case. And just to mention, we did a case which we got a successful judgment on close on 2 years ago now, called the Deadly Air case. And that one, the court actually held that right to the environment that's not harmful to health or well-being is immediately realizable. So some of the rights are progressive, but this one was held to be something that everyone is entitled to here and now, which was a huge victory, especially on paper. In reality, it's more challenging. How do you actually take a judgment like that and ensure that it means that people's lives on the ground improve? So that's something that we're grappling with. Then other rights that were raised is there's a right that decisions made that affect children should be taken in the best interests of the child. So that's a very strong one that we put in there. Then there's a right of access to food and water. So that right was unpacked and also is part of the claim. A right to equality. We know that climate change impacts really hit the poorest communities the hardest. And South Africa, due to our historical legacy, those are Black and brown people effectively. So for the most part. So also making the case that right has been compromised by decisions like that. Yeah, so those are the different sort of things that we bring in, and to do that, we really relied heavily on expert evidence. So there's sort of an energy economy modeling aspect to it that shows that building new coal-fired power is in fact not the least cost option, and that the economic benefits and job creation potential of building renewables instead, for example, far outweighs the new coal. We got a report by a clinical psychologist on the mental health impacts of climate change, especially on the generation. Brought in some climate science reports, including a projection of what the impacts are likely to look like 10 years, 20 years, 30 years, 40 years from now. And then an angle that we're expanding on quite substantially is because the impacts of climate change are going to hit future generations the hardest, that there's an additional duty of care on the part of decision makers to ensure that children and the youth are adequately consulted, which they didn't do. And similar to the way that we're developing the kind of enhanced rights of the youth, if you like, or putting a spotlight on that, we're starting to do that with women now as well, knowing that they also bear a disproportionate impacts of climate harms for a range of reasons. And so when we're doing our advocacy work around electricity planning, for example, we're starting to bring that in, and in that way developing the human rights linkages, if you like, with the issue of climate change. Let me leave that there for now. Thanks.
Thank you very much, Brandon, for providing that overview in terms of what your experience and the role of NGOs actually conceptualizing this human rights approach to climate litigation. So, from an African continent, without human rights, there's no climate litigation really. So many of these cases are actually from a human rights consideration. So that would just lead me to Dr. Chima, and to ask Chima the same similar question, but using his own experience from. I know Chima has worked with a lot of NGOs, a lot of activist NGOs, and he has a lot of experience in this cases. So my question to Chima is that, similar to what I asked Brandon as well, when you package climate change as a human rights issue, in terms of how can NGOs bring the matters to regional and sub-regional bodies? So I'll just took this question a bit from your experience. I know you are very conversant with the BMRE issue and other issues that have taken place in Nigeria and other foreign jurisdictions. So what is your take on this move by NGOs to not just use regional judicial bodies, but also use foreign jurisdictions as a way of promoting climate justice for the most vulnerable in African societies? So that's my question for you, Mr. Chima. You can use your experience with the various NGOs to basically provide us some clarity on that issue. Thank you.
Yeah, thank you, Dr. Gosa. Thank you, Brandon and colleagues. Well, for us, it's been a long, tortuous struggle to bring the issue of climate to the understanding of average Nigerians and the people that wield power and the corridors of power, to even sensitize people to understand what climate change is all about in the first place, and then the impacts that are derivable from there. And we tried, as a civil society organization, we had an international, if you like, coloration on campaign to end gas flaring. And of course, gas flaring is the one activity that makes Nigeria the greatest greenhouse gas emission contributor from Africa, and I think third in the world. Okay, so ours was like, how do we bring this down? And that is how we conceptualized the John Agbemre's case against gas flaring. And of course, we had to collaborate with different groupings across the world, both science-oriented groups, historical oriented groups, and of course, environmental groups, for us to look at it in a compact way. And when Egosa talked about John Agbemre against Shell, that is the foundation of litigation on climate, because that is the first case ever in the history of the world that mentioned climate change while discussing environmental rights. Okay, so it is sort of bringing all the issues together, looking at climate change impacts, how does it affect the enjoyment of our fundamental rights, and the rights that are provided under Section 20 of the Nigerian Constitution and Article 24, if I'm right, of the African Charter on Human and People's Rights, that talks about the right of people to live and enjoy their environment that is, that is supportive of their growth and development and the enjoyment of life. And in John Agbemre's case, gas flaring, which exacerbates climate impacts, was held by the courts to have violated the Nigerian citizens' right to life and right to dignity of the human person. So from there, we now continue to leverage on that positive decision to begin to campaign on issue of climate impact, climate justice. Because of course, climate justice cannot be achieved in the absence of environmental justice. It's not possible, because climate impact is a subset of environmental impacts. Because for all that will happen, the frontline communities that will suffer most in Africa from the impact of climate change, it first destroys their environmental rights. Rights to livelihoods, rights to a good and enjoyable life, because when, for instance, in the Nigerian situation and most other African countries, the instance of flooding, let's look at that. When it happens, it does not spare anybody, and it does not spare any of your rights, because first, you have to be alive to protect your political and economic and other rights. And secondly, when it destroys your foundation, the foundation of your livelihood, then you can imagine what goes with it. And of course, the health challenges that are created when it happens. If you look at all of this, for us as a group, we have been working to enlighten both governments, both citizens on this issue, including efforts to get the parliamentarians to enact both either environmental law, and as we had it, Nigeria became one of the first African countries to have enacted Climate Change Act, and we were instrumental to that. We were part of those that worked on that bill when it was a bill, before it was reworked and assented by Mr. President. But what we finally got, yes, it's not something that what we wanted, but it is better than having none. So this is how we have been working. Our job had been, to look at all the stakeholders, if you like, to bring them into the loop on the discussion of climate justice. I think I can stop here and then wait for other questions. Thank you very much.
Very much, Dr. Chima. Dr. Chima, I did not introduce Dr. Chima. Dr. Chima has a lot of cognate experience. He has worked with a lot of NGOs in Nigeria, and is currently Principal Chima Williams and Associates and Country Focal Person, Public Interest Initiative for West Africa, Nigeria. So in terms of climate advocacy, in terms of climate mitigation, in terms of environmental litigation, Dr. Chima is one of the stakeholders that have actually pushed environmental litigation to the front burner from a Nigerian perspective. So our next speaker on the list is Dr. Daniel Owona Mbarga. Apologies if I didn't spell your name properly. He's a lawyer at Field Legality Advisory Group. Welcome, Dr. Daniel. So similar to the same question that I've asked every other panelist, in terms of what is your experience in terms of this conceptualization of human rights and climate justice, and do you have any experience in terms of, not necessarily maybe foreign litigation or regional litigation, in terms of what is your own experience of litigating human rights and climate change issues from your own perspective in your career as well so far? So we'd like to get your perspective on this issue as well. Thank you.
Thank you, Dr. Egosa. First of all, I would like to apologize for my English, which is not perfect. If I hope I will be understood, and if necessary, maybe participant could read my chapter on in the book of Dr. Kimbawa on climate change, justice, and litigation, as I think I write better than I speak. Concerning the question you asked to me, Dr. Egosa, my organization, Field Legality Advisory Group, does not work on litigation as a core mission. We analyze litigation, environmental litigation across the Congo Basin. And also, if needed, we support communities that would like to sue enterprises or companies or maybe administration due to offenses, forestry offenses. So from my experience across the Congo Basin, we work with NGOs that are doing independent forest monitoring or even natural resources monitoring in the Congo Basin. I've read almost 100 reports of these NGOs, but I've not seen a report that frame offenses as human violation. It's not because they are not existing, but they are more focused on maybe presenting it as a violation of the labor code, the labor law, or even just the timber, the forestry law. So we could have offenses such as the violation of the right to adjust, adjust work in suitable condition as provided by the Article 7 of the International Convention on economic rights, but they will not add, they will not mention this international text. They will not mention even regional text, African Charter, to mention that this is also a violation of human rights. So that's why if we are willing to put in evidence, to put more in front climate change as climate change litigation, they should move from the perspective that is more focused on just the labor code, the forestry law code, the forestry law, or even the environmental law, to add also specific instrument that could be helpful to raise one human rights during forest.
Hello, Dr. Daniel. Have you finished, or have you lost? I think we've lost Daniel's signal. We'll just wait for him when he comes back, and we'll continue. So our next panelist is Dr. Michael Onyanko, who's the Manager Litigation Implementation Center for Human Rights, University of Pretoria, South Africa. I know, Daniel, you are based in an educational institute. I know the Human Rights Center is in Pretoria is very known for its innovative advocacy, sort of like an advocate and this scholarship publications, etc. So I'm just wondering, from your own perspective, how would you see the role of such institutions in the
Hello,
propagation?
sorry.
Okay, so okay, we lost you for a few minutes. So can you just quickly round up, Daniel, so we can move on to Michael, please? Daniel, can you continue, please? You were about finishing your answer, so.
Okay. Okay, thank you. There are some constraints in the laws of some countries in the Congo Basin that prevent NGOs to also do climate litigation in our tribunals. Especially in Cameroon, there is a provision in the environmental law, our environmental law, that obliges NGOs to be agreed by the ministry in charge of environment to show or to take into account needs of communities before tribunals. That led the association club QHSE this association did not win its case because of this constraint, as it's a case similar to the Save Lamu case in Kenya, but the administrative tribunal said that it's not association. The association have not been agreed by, did not get the agreement of the ministry in charge of environment to contest the environmental certificate that have been delivered to gas of Cameroon to construct a pipeline. So that is the case of Cameroon.
I think we've lost Danny again. We just wait.
This is the case of Cameroon, but in other. That is the case in Cameroon, but in Gabon, they don't have the same constraint. The association could sue a company or administration without any constraint that is mentioned in the environmental law. So I think I will give you the speak, Dr. Egoza, as I have issues.
Thank you very much for providing that perspective, especially from the Francophone African perspective of this issue, and what your law firm is doing in terms of researching various climate mitigation cases. As I was saying, we'll move on to Dr. Michael Onyanko, the Manager Litigation Implementation Center for Human Rights, University of Pretoria, South Africa. The Center for Human Rights, Pretoria, South Africa, is renowned for its human rights activism, human rights advocacy. It does a lot of engagement with the African Union, with the various institutions of the African Union as well. So my question to Dr. Onyanko is just basically from the perspective of an educational institution of like the Center for Human Rights in Pretoria. So what do you think such institutions, what role should they play in this move towards climate mitigation from an African perspective? So that's my question to you, Michael.
Thank you very much, Dr. Ekato, and good day to fellow panelists and colleagues who are our audience. I think as an academic institution, we are interested in the full spectrum of human rights research, advocacy, capacity building, and every now and then litigation as well. And we see our role as educating the next generation of human rights defenders across the continent, which we engage in through the training of postgraduate students in human rights with a particular focus on the African human rights system. So that we use education as a means of, growing a critical mass of other, human rights defenders who will then go to the ground to educate communities about what exactly are the standards that are at stake and how to utilize the available mechanisms to vindicate, those kind of standards. But we're also very interested in research and documentation, because litigation can usually only happen effectively if we've got the information that is put together properly in a manner that is easily understandable by the people who are litigating, but also the adjudicators. Because it's often difficult to litigate when there is a bit of disconnect between what exactly is the understanding of what these issues are between the people who are litigating, but also the individuals who are the adjudicators. So we are also interested in the capacity of the adjudicators as well. And that one of the roles that we think that we can play is to also, build the capacity of the judges or the leaders of tribunals or whatever, in whatever capacity these individuals may be acting, so that they understand what exactly it is that the concerns are, which standards we are seeking to uphold, and what is their own role in, in upholding these standards. And then, of course, occasionally we also engage in litigation ourselves, as most often intervening as amicus where there is particular cases that are being litigated. I think our most recent intervention was actually in the Inter-American Court with regards to this advisory request that was brought by Chile and Colombia, requesting the Inter-American Court to provide some interpretation on what is the obligation of state parties with regards to climate change. And we were particularly interested in human rights defenders and how any kind of climate response legislation or measures should take into consideration the impact of climate change on human rights defenders, especially those that protect the environment, and the kind of violations, reprisals that often either governments or corporations themselves are using against them when they try to hold these kinds of corporate actors or occasionally governments accountable for climate change violations. So essentially, that's the nature of our interest in climate change litigation. We have even explored the possibility of approaching the African Court itself in the context of what would be the obligation of African states towards protecting communities against climate change, but also what measures they should be adopted to have more inclusive transition processes within the African context. So that broadly is how we see our mandate, and how we think that university-based NGOs that have the capacity to educate, to build capacity, and to do research and litigate can play their role. And I'm happy to engage further in subsequent questions.
Thank you very much, Michael. So I think this also shows brings to fore the sort of the plurality, of the diverse voices in terms of NGO and non-state actors. So if we talk about NGOs, really, I think for me, it's not just conventional African-based NGO. It can also include non-state actors, can also include institutions, can also include individuals as well. So in a way, I think for us, the relevant stakeholders from an African continent includes not only the known NGOs, include the ordinary stakeholders, activists, and as well, I think universities in Africa has a massive role to play. Think tanks in Africa have a massive role to play, because the examples you provided should be an exemplar on how other African universities, other African institutions educational institutions can actually leverage on their expertise and have that direct impact. So for me, I'm just thinking, if you're from West Africa, for example, and you have a lot of ECOWAS cases, what are West African universities doing in that regard? So I think the advantage as an outsider who doesn't live in South Africa, but the advantage that Pretoria has, that the access to most of these courts, the access to expertise that you have, I think many universities in Africa do not actually have. I think for me, that should be something going forward, could be a standard for other educational institutions can actually adopt and use that as one way to actually impact on climate advocacy and litigation on the continent. Thank you very much. So the next set of questions, I will start with Brandon in this regard. So we've talked about the roles of your activism, the impact that you've done in South Africa and different NGOs. So my question to you is asking you, kindly give an overview of the different types of NGOs in this space and the strengths and opportunities and risks and weaknesses of it. So I know we have a lot of NGOs operating in this climate advocacy litigation space. So just kindly give us an overview and strengths, opportunities, risks, and weaknesses of each of them if you can. Thank you. We've got 5 minutes. Thank you.
Thanks, Doctor. Yeah, so we'll speak from the perspective of the climate justice space predominantly and environmental rights space. So just looking at it, that the different levels of NGOs and civil society engagement, and it's worth sort of unpacking those just to understand the different levels of influence and effectiveness. So I mean, ourselves, we're quite specialized. We generally, most of our staff are attorneys. The resources are never enough, but we are relatively well resourced compared to many. And obviously have this sort of expert knowledge to draw on and a very kind of clear focus or almost narrow focus area coming from a legal perspective. Then some of our clients are kind of more formalized environmental rights groupings. So they tend to also be reasonably well-resourced, well-staffed with good experience and good expertise. And they tend to work with a range of issues, not just as narrow as perhaps we do, and across a range of locations. And then we have the very grassroots groupings. So those tend to be localized in an area around particular issues. For example, some of our clients are groupings that live east of Johannesburg, where all the coal-fired power stations are. So we've been working extensively with them on air pollution and increasingly on climate change. So I guess from a strengths perspective is the ability to really pull people together. I think the nature of the work and the cause and the struggle, if you like, does resonate with many people. And along with our experience, really being able to pull in networks and role players from all sorts of levels and different fields and disciplines. And this is really useful for developing arguments around the intersectional nature of the climate impact. So we work with gender justice groups, with economic justice groups, health impact groups, youth groups, and that sort of thing. And that really, I think it's a nice symbiotic relationship between all of these different groupings that allows all of them to gain strength and develop arguments and raise understanding. I think it's come up a few times that the understanding of climate change is not what it should be, whether we're talking about people at community level, whether we're talking about judges, whether we're talking about parliamentarians. So all of our work, we try and make as public-facing as possible and have accompanying public relations and strategic communication. A strength as well is this access to expertise, so strong academic support in many different fields, which is good both locally and globally. And then I think the passion of the people. I think people that are in this field and stay in this field are here because it really matters a lot to them. From a risk perspective, yeah, they'll be different. I mean, funding is always a risk, but we're talking about much more tangible risks such as safety and security. We've had assassinations in South Africa, certainly not as bad as other parts of the world, especially South America, but it happens. Intimidation, that kind of thing, people disappearing, people's IT systems getting hacked and all of that kind of thing. And that's where the most informal level of NGOs the highest at the highest risk. I mean, these are people that live in the communities, and it's particularly at risk when when there's a challenge to an existing project or a project that's imminent that promises to provide jobs, because then you'll have maybe some in the community that are working at that project already. And obviously they go head to head with those that oppose it. The political narrative in South Africa is quite a risk for all the different levels. And it gets spun as development versus climate action, which we know is not the case, but those who protect and advance the fossil fuel interests like to use that one. And the conditions, the socioeconomic conditions that we have in the country make that narrative gain traction, if you like. High unemployment, high inequality, and then this electricity crisis that I mentioned. So, yeah, at the end of the day, we need to win the hearts and minds of people. The more support there is for making the right decisions, the easier it is to win court cases, to convince judges, to sort of influence the political will. So that's quite a big one that we need to deal with. And then there's also the sort of global climate justice perspective. I mean, we know that the global north is responsible for the historical emissions, and they owe the global south a huge debt. So South Africa, as part of the global south, obviously joins other global south nations in demanding the finance, demanding the loss and damage funding, demanding the adaptation resources, etc. But then from a different level, South Africa does owe the rest of Africa climate debt. We're the 13th largest emitter in the world. We have one of the most carbon-intensive economies in the world. And our emissions are significant, not compared to China or USA, but nonetheless there. So we also need to watch that our politicians don't play that card too strongly at the expense of taking sound climate action as a country as well. Yeah, thank you.
Thank you very much. Thank you for providing the various perspectives on the issue. So my next question would be for Dr. Chima. So we know we've talked about the Benways case, which is a Nigerian case that has a lot of impact on how we conceptualize the human rights approach to climate litigation. So I'm just wondering, Dr. Chima, what do you think? Look, I know there have been a lot of foreign litigation involving regulation of multinational corporations in different parts of the world, in the UK, in the Netherlands, in the USA, etc. And there's also been some of these cases have actually been seen to be foreign climate litigation in the context of a Nigerian perspective. So my question is, what has been the impact of this foreign climate litigation, or foreign litigation and regulation of multinational corporations in Nigeria? So why do we even need to litigate outside of Africa, outside of Nigeria? Do these cases actually have any impact? And as for someone who's actually involved in the advocacy and this litigation, so I would like to get some sort of like understanding and clarity from your own perspective on this issue. So we talk about foreign litigation. Why do we even need to engage in litigation outside of the shores of Africa? Do we even get any benefits? So that's my question to you, Dr. Chima. Thank you.
Right. Thank you, Dr. Gosa and Brandon. Of course, this question always comes, why litigate outside of the shores of Nigeria? That is a very simple answer to that. We do home country litigation because the host country litigations, even though they've been successful, for some of us anyway, but it is one thing to get a judgment, and I think is Brandon or the other guy talked about, the judgment being a paper. On paper, you have good judgments, but in practice, in reality, is that judgment effected? Is it implemented? Okay. Now, this is where the challenge has always been. And from our own engagement in litigating at the home country level, we've seen quite a lot of differences. You know, 2021, I would say, was the Nigerian legal year in terms of home country litigation, okay, because it was in 2021 that we had the judgment of the Dutch Court of Appeal, where the four poor farmer fishermen in Nigeria, brought the almighty Shell to her knees by defeating them in court. And Shell accepting, which is something that they rarely do in Nigeria, accepting that judgment, not appealing against it. Of course, they have the right to appeal against that judgment to the Supreme Court, but they chose not to appeal against it. And then, rather than us two going forward to, which is when you've gotten a favorable judgment, if you want to make claims for damages or compensation, that's another level of litigation, okay? And Shell avoided that by agreeing with us or calling on us for us to discuss a settlement that is acceptable by all the parties. But I will tell you that with that case, even though it was not directly a climate litigation, but whatever impacts on the environment impacts on the climate and impacts on the rights of people and human beings. For me, as an environmentalist, the biggest victory that we won with the 4 fishermen farmers case against Shell in the Netherlands was the decision on directing Shell to install a in Oruma community so that there will be real-time monitoring of, oil spills and the likes, so that it can be attended to immediately. Now, what is the impact of that kind of judgment? It means that the companies have to take extra care to ensure that their operations movements, can we link it to issue of climate using the ocean science, components of climate litigation or climate science, okay? So for us, I think that, yes, the beauty of it is that we can get judgments at the whole country level and it will be implemented, whereas in Nigeria, the reverse will be the case. I'll tell you this. The Jonathan Agbenre's case was the case that buoyed us up to do the home country litigation. Shell in 2005, November 2005, but all manner of Shenengai practices was brought in by Shell and their government, collaborators. Now you can imagine, Stephen Wokode, sorry, who presided and delivered the judgment against Shell, was immediately transferred from the Niger Delta, where oil impact occurs mostly, to up north. And then at that time, President Umaru Musa Yar'Adua, may God bless his soul, was the president of Nigeria. And Katsina has nothing to do with anything related to oil practice and, some of the greatest environmental issues that we're campaigning against. Justice Stephen Wokore was transferred to the Federal High Court in Katsina, in the president's state. Okay? And after a while, he was set up and booted out of the judicial system for standing on what is right. And the judge at the Court of Appeal that had the appeal of Shell for stay of execution without hearing arguments from either parties, whether Shell or us, didn't hear any of the arguments. The effectuation of that judgment order in John Agbemre against Shell until the issues are determined. And with that, Shell ran amok all over the world to say that there was no judgment against them. And the judge, the presiding justice that delivered that ruling, was promoted 3 months after to the Supreme Court. Okay, you can now see the, the balance. The one that stood by truth was destroyed. The one that, did the wrong thing was promoted. So, word of encouragement. So, and this stemmed from the fact that the government of the time was in cahoots with the multinational oil companies. But we had, a sort of good news for us when the last administration of President Muhammad Buhari came on board. And maybe because of the president's declarations at various international fora against, gas flaring and climate issues position, Shell on her own, after 13 years of denial of the existence of the judgment against them in the John Agbemre's case, now decided to appeal, okay, against that same judgment that they have always been denying its existence. So now, if we draw now in contrast, Shell used every type of, mechanism within their disposal to ensure the non-effectuation of the judgment in John Agbemre against Shell. The same Shell, in the 4 fishermen farmers case against Shell in Netherlands, agreed to settle. I mean, I think if we can look at it, we will understand the divide. Okay, not just agreeing to settle, but entered into settlement negotiations, of which I was part of. And we concluded they effected the rumor and they accepted the outcome of our negotiations, that agreed on an amount to pay as compensation to the victims, which they promptly paid. But in Nigeria, in Africa, that will never happen. So for us, this is one of the reasons, primary reasons, why we take our case, or we advise taking some of these cases out of the country, the host organizations. Now, let's look at the other side of it in terms of development of the law and judicial processes. Decisions that have come out from Europe and America in terms of citizens' litigation on climate issues. Yes, distinction drawn here. In most of the cases, it is targeted at the government, okay, which will be a challenge for Africa, because if we are targeting out our governments, we cannot litigate outside of the shores of the country, because territorial integrity and sovereignty will be brought to bear and the case cannot be heard. So because we look at all the sides, internally, we will litigate against our government. Externally, we will litigate against the corporations who are coming from different parts of the world. So if you mix this, you see the beauty of external litigation, that you can get some of the things that will be difficult for you to get from an African country court in an European or American court. One, if you get that, the chances of implementation of the outcome of that litigation is higher. And litigation will mean nothing if we have, like the way we have the John Agbembe's case that is still languishing in court up today, how many years after, okay, the first judgment was delivered. It continues to hang in the courts. So you cannot implement outrightly because the other party has the right of appeal. So why do they do this? Because in Africa, they have at our course of action, the issues that we want to bring to court, to decide and look at it to determine the appropriate jurisdiction that can handle such matters and will get our reliefs delivered. Thank you.
Thank you very much, Dr. Chima. Thank you for providing such clarity and such. You could see your passion. You could see the reasons why you're doing what you're doing, even though it's very, very difficult. We know it's very difficult to actually get justice in many places. Personally, I always believe that justice is not always the goal. It's having access to justice, having that opportunity of people trying to get justice. That has always been the center fulcrum of my research. I know sometimes justice can be something unachievable, but do we have the processes to improve access to justice? And your answers basically provide that clarity, notwithstanding the difficulties, the obstacles. You've been able to use the existing framework, existing legal strategies to actually try and get a bit of closure and justice. And it's quite difficult. How many people can actually get justice? How many Niger Delta citizens can actually get protected? So at the end of the day, we need to have like a more concerted sort of strategy, multi-pronged strategy. But what you're doing as an individual and the organization, I think, is extremely useful in this discourse we're having. Thank you very much. So, Dr. Daniel is no longer around, but he has answered the question which I've asked him. So I'll provide the answer to the question in the chat in a few minutes. So our next question goes on to Michael. Michael has talked about the background of what the Center of Human Rights is doing in South Africa. So here's a follow-up question to Michael's first question. This question says, what is the role of NGOs in empowering individuals and communities through human rights education towards preparing the ground for litigation and other advocacy measures? I know you alluded to a bit in the answer to the first question. Just provide further clarity in terms of what NGOs should do in terms of human rights education in preparing the grounds for litigation and other advocacy measures. Thank you, Michael.
No, thank you very much, Dr. Kato. And I think I did indicate earlier that litigation happens within a particular context. And it happens where the people who are seeking to seek redress for their rights actually understand what redress they are seeking and the avenues to seek that redress. So that we think of one of the core ways through which NGOs can facilitate climate litigation, especially those targeting corporations, is the interaction, especially in the processes of environmental impact assessments and so-called social impact assessment, or even human rights due diligence these days, which forms part of the social license that, many corporations, especially those that work in the extractive sector, usually require to be able to operate. And we think that it is fundamental that NGOs play the role of empowering communities in a manner that they are able to effectively participate in the consultation processes that result in these kind of environmental and social impact statements that extractive companies are usually required to have in place before they begin any kind of exploitation of resources. And that when those communities or entities are then educated enough to be able to participate fully in these kind of consultation processes, whichever impact assessment statement that comes out of that process would sufficiently provide avenues that protects the rights of communities. And these then form the basis for subsequent litigation where the corporation is not complying with those obligations that are outlined in those kind of social impact statements that they are supposed to adopt at those levels. But also, I think significantly, NGOs can play the role of supporting communities to litigate where they have the capacity to do so. And I know there are a lot of NGOs that does this. We hear from Brandon the role that the Center for Environmental Rights is playing in supporting communities to challenge unlawful conduct by corporations, but also sometimes unreasonable approvals that is given by state departments that are supposed to be the ones that are monitoring the implementation of the relevant standards. So the continuum of educating at the grassroots, enables NGOs to then follow up to monitor whether or not the agreements that have been reasonably reached between communities and extractive, industry or corporations are being complied with, and where those standards are not being complied with, whether the capacity exists to bring this kind of litigations at whether national level litigation or even within regional human rights mechanisms. I think NGOs can even use avenues such as state reporting processes where state parties go and report to whether the African Commission, the Committee on the Rights of the Child, or any of the UN human rights mechanisms to raise awareness about the kind of violations that have potential impacts for climate change, which are less contentious, but still are avenues through which we can hold state accountable in a less litigious way, but which can have lasting impacts. And I'm sure entities like Prof. Damilalu's outfit of the working group also are avenues where specific instances where violations are occurring may warrant the attention of civil society organizations that have the capacity to raise this kind of interactions at that kind of level. I think also broadly, we think civil society can engage in the sort of standard setting that is ongoing at various fora. There are many organizations, especially within the UN, the African Union itself, that are developing guidelines, general comments, all these kind of standards that then are being used at the domestic level to litigate as a basis of holding states and corporations accountable. And if we get the right standards set at that level, then we've got a better chance of being able to get the kind of right decisions made at a domestic level. And that the kind of bottom up from the grassroots up, but also ensuring that there is the appropriate standards that are being set from the top down, allows NGOs that have capacity to play quite a significant role in setting the scene with ability to educate communities to know what exactly they are up against and how to navigate those challenges and support them to bring relevant litigation where appropriate, but also to engage in significant interactions with the relevant institutions that are setting the standards, so that we don't have skewed standards that could potentially have negative impacts. And I think there are many NGOs that can also provide the capacity to support the coalition of NGOs to take joint action. And we, for instance, provide assistance to the African Coalition for Corporate Accountability, which is a coalition of over 130 NGOs that work towards environmental protection and other kinds of climate change related harm that societies and communities suffer. And we do this by providing, hosting as a secretariat of the coalition, but also providing technical assistance to the kind of research that they engage in, and essentially holding the coalition together to have a unified front in the negotiations currently ongoing in Geneva towards the adoption of a binding treaty on corporate human rights obligations. So there's a multitude of things that NGOs can do, and I hope that this sheds some light on some of the things that the role that we can potentially play in this regard.
Thank you very much, Marco, for the clarity and for the various suggestions you've advocated in terms of how to ensure that NGOs can collaborate, NGOs can work together to ensure that climate justice actually being done.
If I may ask something quickly, I think one of the things that we have also explored, which I've seen other organizations do, is to develop a sort of model arguments of the kind of arguments that organizations that are seeking to litigate could actually make, so that for organizations that don't have the capacity to have the expertise to develop their own arguments, there is a standard set of arguments that they could easily sort of adapt to their own circumstances. That does not require them to now hire lawyers and experts that could cost them a lot of money. So organizations such as ours, who have the capacity to sort of develop these kind of arguments, can do that, so that it's publicly available, and it enables organizations that has much less resources to easily take these arguments, adapt them to their own context, and to litigate in their own circumstances where appropriate. I just wanted to add that quickly.
Yeah, thank you very much. I was going to go to Brandon next, but this is going to be the last set of questions. You just raised a very important point, Mark, in terms of having this model argument. So my question to you is going to be a 2-in-1 question. So how can NGOs access this model arguments? Is it something you give to NGOs for free? Is it available on your website? So how does that work? Then two, my second question is, so what are your views regarding this Malabo Protocol and the potential for climate litigation? So I know the Malabo Protocol talks about corporate criminal responsibility, liability, etc. So is there an avenue, because we tend to focus on the African Court of Human Rights, the ECOWAS Court, EACs, etc. So is there a potential role for climate litigation via the Malabo Protocol in that regard? And vis-a-vis in terms of the model argument you've made as well. So we just have 2 minutes to just do that, so we can round up on time. Thank you, Michael.
No, thank you. In terms of the model argument, our own model of work is to provide information available for free. Even when we publish books, it's published for free because we want to make information available. So if we develop such model arguments, it would be completely available on our website, free of charge for any organization that would be interested in having access to them. We haven't developed such arguments yet, but I've worked on a project that developed arguments in the European context for litigating at the European Court, and that's what informs my understanding of what we could also be doing within our own African context on developing arguments that could work both at a domestic level, but also looking at the regional landscape, the kind of arguments that we can make, and that if we have those kind of model arguments in place, then perhaps it will facilitate the ability of many NGOs to litigate. Because I think we've heard a lot of stories told about the enormous level of violations vis-a-vis the limited sort of accountability that we see in terms of litigation and other kinds of coercive measures. So I believe we should strongly explore that kind of possibility. In terms of the Malabo Protocol and the future of corporate climate litigation in Africa, I think it could become very interesting very quickly, because the Malabo Protocol provides for corporate criminal responsibility, and especially in the context of climate change. There is Article 28L of that protocol that talks about the trafficking of hazardous waste in contexts where these waste, could also have impacts on climate. There's also the issue of illegal exploitation of natural resources, and the treaty specifically speaks about exploiting natural resources in a manner that's environmentally unfriendly. So in the instances where we are talking about corporate human rights abuses, it is going to become a real possibility very soon that corporations that are exploiting, natural resources in ways that are environmentally unfriendly could be, criminally charged at the criminal chamber of the African Court on Human and People's Rights, which, beside the corporate responsibility, also has individual responsibility for the directors and, if you like, other chief officers of the corporations. The protocol has been adopted since 2014, and surprisingly, Angola this year has actually ratified the protocol, being the first country that has ratified the protocol so far. So our hope is that this is a momentum that allows other African states to also ratify the protocol. And once we have 15 ratifications of that protocol, there is the possibility of actually being able to bring real criminal complaints against corporations for these kinds of violations that have significant impact on climate change. Is a thing that perhaps will become the first in the world through the African Union, and hopefully could escalate to the international level. We know of talks within the ICC of potentially having the crime of ecocide as part of the international crime that court would potentially adjudicate on. But it appears that the African Union's court would potentially be the first international court that would have this kind of corporate criminal responsibility for environmental harm that have impact on climate change. I just wanted to end on that. Thank you very much.
Thank you very much for giving us pointers in terms of the future of climate mitigation from the African continent, and also telling us that the sort of the plurality, the potential of the AU sort of legal framework. So we need to finish very, very quickly. So I'll just have one question from Brandon and one question for Chima. Please, you have just 1 minute to answer this last question. So for Brandon, this question is for you. It says, kindly explain different programs of the Center for Human Rights, how this fits into the potential for corporate climate mitigation in South Africa. Just 1 minute, please. Just briefly explain how your programs fit into this potential for climate mitigation, even especially with the potential signing into law of the climate change bill in South Africa. Thank you. Just 1 minute, please.
Thanks, Doctor. I'll be quick. Yeah, so our program's work has generally been against the state decision-making and very much mitigation focused. And we're starting to see the need to evolve that onto the adaptation and climate resilience side as well. And we're also seeing the need to start focusing on the corporates more. So we've recently put together a report called Polluter Pays for Climate Loss and Damage, and that explores using South African law of delict or tort to go against carbon majors. And it uses the example of a flood that we had in our city of Durban 2 years ago, and really sort of unpacking the attribution science, looking at the wrongfulness, the causation, and all of those kinds of things. Yeah, and then just on the climate change bill, it's not been signed yet, very frustratingly, but just to say that we've been engaged extensively on advocacy to strengthen that. And on that issue of model arguments, etc. So when we engage with advocacy around something like this, we also make available the potential inputs that people could adopt when supporting certain kinds of legislation that comes in, and that we also like to make very, very publicly available. It's a bit more tricky with model legal arguments because each, as effectively being attorneys, we can't dish out what looks to be legal advice in appropriate circumstances. But yeah, most of it's about opposing fossil fuels. It's been coal, it's becoming gas increasingly. But we also need to expand the work to not only oppose what's being destructive, but also help facilitate what's more promising, such as the shift to renewable energy. Thanks.
Thank you very much, Brandon. For Dr. Chima, this is for you, and this is quite similar to the question which I asked Brandon. I know you've talked about the Climate Change Act in Nigeria. So my question to you is that are you okay? Just briefly mention maybe one or two weaknesses of the Climate Change Act, and so are you aware of any potential litigation that is being prepared to be premised on the Climate Change Act in Nigeria? So to my knowledge, there's no litigation pending, but are you aware of any pending litigation? So some of academics, including myself and Dr. Zwazo and Dr. Kimba, have argued that there's a climate litigation potential in the Climate Change Act of Nigeria. So my question to you is that what are the weaknesses of the act, and are you aware of any case being prepared on the basis of the Climate Change Act in Nigeria? Thank you. Just 1 minute, please. Thank you.
All right. Thank you, Dr. Gosa. In terms of the Climate Change Act in Nigeria, so far, there is no known legal or litigation plans against the act, but there's been campaign, for a review of the act. Right from the day Mr. President signed the act, those of us that worked on the act, started immediately calling on the Climate Change Department of the Federal Ministry of Environment, to join hands with us to review the act and then cancel the obnoxious provisions. You can imagine a climate act that, instead of giving position to end, fossil fuel extraction as part of achieving a reduced climate impact activity in Nigeria, is encouraging the search, and not only the search, using state resources to research for new, fossil fuel finds. Okay, and a Climate Change Act that promotes, clean development mechanism issues, whereas we know that development mechanism being a mercantile provision, to encourage people in the North to continue to enjoy their life and continue to destroy those of us in the South, and then give us a paltry, which goes round back, round trip, back corporations of northern origin. So these are some of, the faults that we have seen among many others. Is a case does not mean that we are not thinking of, a litigation to bring the provisions of the Act and other relevant, treaties that Nigeria has signed onto, and then bring Nigeria to sign onto those that have not been signed. Of course, we had tried on the effort of Ecocide, bring
Barrister Chima, I think unfortunately we've lost you. So I think due to time reasons, due to we all starting late, we might need to draw this session to a close. But this is not the end of the conference. Conference organizers will be here to formally close the workshop. And as panelists, I wish to thank everybody for contributing to this amazing panel and for providing different perspective for many of us who are scholars, and not everyone is a scholar activist. Some of us are just conventional theoretical scholars. Some of us are activists. Some of us do not have access to the information. Some of us do our research on Africa based in Western institutions. So having Michael, Brandon, Chima, and Daniel, and providing that sort of overarching, those various dynamic perspective that shows that yes, there might be this view that climate mitigation is in its infancy in Africa. We don't buy that view. We don't believe that Africa do not have the legal framework to tackle climate litigation, climate injustices. It's for us as academics, as stakeholders, as ordinary people to come together and see how we can hold government, MNCs, and emitters to account, and not just saying that MNCs have got moral responsibility. We need to look for one way or the other to hold every single entity that is supposed to be held accountable, and as much as possible ensure that the ordinary people get justice at the end of the day. And justice should not just end in the books we write, in what we read. Justice should also go to the people that actually bearing the worst of climate injustices. Thank you very much. I will invite Ivano to formally close this workshop. Thank you.
Thank you very much, Dr. Igosa, for that very good panel that you have chaired. And I think we've gotten quite significant insight from Brandon, Chima, and Nyarko. And ours is to thank you in a very special way for sharing your perspectives, which of course reinforce different aspects of corporate climate change litigation with our audience today. And I think this also sets the ball rolling for any future collaborations in this area, because climate change mitigation on the African continent is just taking off. And really, as it takes off, then it is incumbent upon us to shape this discourse. And we don't shape it any better than creating jurisprudence. We don't shape it any better than finding cases that need to be adjudicated, that then advance the interests of climate justice and also bring at times belligerent corporates to the table. And it helps them to sit up and listen to otherwise very fickle voices that would not find representation without the activities of the NGOs, academics, and advocates of the continent. Without much ado, I will invite my colleague Uswazo to take over from there. Thank you.
All right, thank you very much. Let me also join in thanking all our speakers for this particular African Summit and all participants as well, those on ground physically and also those who have followed us online. I would also use this opportunity to invite everyone to engage with the BICL Global Toolbox on Corporate Climate Litigation. If you go to the website, the reports of 17 countries and 2 African countries, Nigeria and Kenya, are on that website. And then you go through the Global Toolbox to see the comparison, the latest trends, the hurdles with respect to corporate climate litigation in Africa and beyond. You can download the report. It's for free. I think there's one of the most elaborate discussions on the subject in both countries and in the other countries that are represented in this first phase of the project. As the head of the project has hinted severally, there are plans to expand the project to include other African countries. So keep in touch with that particular website on the Global Toolbox on corporate climate litigation on the BICL website. As in the coming years, of course, you will see more African countries appear with their reports on that particular toolbox. Yeah, so thank you very much. Although the conference is ending on this side of things, but we'll go on after now to a judges training session on corporate climate litigation and a knowledge exchange webinar after now. Yeah, thank you very much.
Thank you very much to everyone who participated in person, online. thank you to the co-chair, the co-organizer, Omondi and Usuazo. It was really a great event. It was really a source of enrichment for all of us. And yes, as Usuazo said, the Global Toolbox is an evolving project, and we are just at the beginning. We are going to add more countries. So we would like you to be involved in this project. I would like also to, in this moment, to just click on the link that Liam posted. So it's a questionnaire, because we would like to know also what you thought about this, what you think about the toolbox, the Global Toolbox on Corporate Crime Litigation. If you can give us some feedback about the event, about the toolbox itself, and provide us with some of your ideas, insights, and please join us. And thank you very much. And I hope to see you very soon. We have an Asian summit on the 8th and 9th of July that will be in Manila, but of course will be also accessible online as usual. Thank you again, and see you soon, and goodbye.